Group 17 of International Law, and our group topic is the uses of force. We specify it to the peaceful settlement of international disputes. So, dispute resolution or dispute settlement is the process of resolving disputes between parties. The term dispute resolution is sometimes used interchangeably with conflict resolution. Peaceful settlement of international disputes and United Nations are related is because the United Nations play an important role in conflict prevention using diplomacy, good office, and mediation. Among the tools of the organization uses to bring peace are special envoys and political missions in the field. Peaceful settlement of international disputes is a fundamental principle of international law of a peremptory character. It is formulated as such in the UN Charter Article 2.3 and Article 2.4 and developed in United Nations General Assembly UNGA Resolution 2625 on principles of international law concerning friendly relations and cooperation among states. The general principle applied in the peaceful settlement of international disputes is Article 2.3 of the UN Charter. All members shall settle international disputes by peaceful means in such manner that international peace and security and justice are not endangered. Meanwhile, Article 2.4 of the UN Charter, all members shall refrain in their international relations from the threats or use of force against the territorial integrity or political independence of any state, or in any other manner inconsistent with the purpose of the United Nations.
The two modes of dispute settlements are the diplomatic method and the legal method. Negotiation allows parties to meet in order to resolve a disagreement. The fundamental advantage of this method of conflict resolution is that it allows the parties to control both the process and the outcome. Negotiation is less formal than other forms of dispute settlements and offers a great deal of freedom. Mediation is an informal yet systematic dispute resolution technique. A mediator is hired to help parties in obtaining an agreeable conflict resolution. The parties cannot be forced to make a decision, and they may or may not agree on a negotiated solution. The confidentiality principle ensures that alternatives discussed by the parties have no ramifications outside of the mediation process. Adjudication refers to the legal process that helps speed up and deliver a court's decision on a dispute between two parties. The process produces a legal binding decision and a court opinion. The majority of adjunction hearings focus on money or non-violent violations.
The International Court of Justice, sometimes known as the World Court, is one of the 6 principal organs of the United Nations. The court's role is to settle, in accordance with international law, legal disputes submitted to it by states and to give advisory opinions and legal questions referred to it by authorized United Nations organs and special agencies. The ICJ comprises 15 judges who are elected by the General Assembly and Security Council and 1 judge from each 5 permanent members of Security Council. Only states may be parties in cases before the court, and consequently, only states may be parties in contentious cases. All members to the UN by its facto parties to the Statute of ICJ. Non-members and non-parties may have access to the court under special conditions laid down by the Security Council. Law applicable to the court according to sources of international law. The decision of the court is binding, final, and without appeal. The court will interpret at the request of either party a judgment where uncertainty or disagreement as to the meaning and ambit the court judgment. A state may request revision of the court judgment and must be requested within 6 months of new fact emerging and within 10 years of the delivery of the judgment, and majority comply with the court decisions.